Lordship, the matter may be passed over for some time. It may be taken as a last item.
What is the matter about?
It is regarding transfer, promotion, retrospective promotion.
So the read petitioner and the current present respondents were promoted on prospective basis. So we have filed a read petition challenging the prospective order, saying that we have been officiating since 2006, and by the judgment of the Honorable Single Bench, we have been given retrospective promotion,
No, this appeal is by whom?
Appealed by the direct recruitees, who were appointees of 2009 to 2018, saying
They are
that
aggrieved by the part of the judgment by which you have been given promotion.
Yes.
promotion retrospective.
And you are also aggrieved because you have been given prospective effect.
Yes,
You
ma'am.
want retrospective.
Yes, ma'am.
You have also filed okay, you have filed a writ petition against the
Well,
order.
yes, madam.
Who is your senior?
It's Bitu Haldar from Guwahati.
Who?
Haldar, Mr. Haldar. He'll taken up as in video conferencing.
Is he there?
No, not yet. Matter may be passed over for some time.
Okay, for some time.
May I please your lordships? Yes, my lord.
Yes,
I'm audible, my lord.
yes, yes.
My lord, in this case, I think last date, no, it was awaited for notice whether served to respondent number 2. I think public prosecutor is supposed to appraise this honorable court, lordship.
Yes.
Instruction not yet received.
Lordship. Lordship, may I submit?
Yes.
Lordship, I'd like to press for my IA, lordship.
IA for?
IA for release, lordship, under section 389.
IA for what?
IA for release of the appellant during the pendency of this appeal, lordship.
Conviction under what?
Conviction under section 307 and 326 IPC, lordship. It's basically,
No.
there is no eyewitness. It's basically on circumstantial evidence, lordship. So,
You want
and
bail pending appeal?
yes, lordship. And
No,
lordship,
again-
as per my instruction goes, the appellant at present is not having a good health condition, lordship.
What is
So-
his problem?
His lower limbs, he is suffering from pain, lordship. This is my instruction, but I don't have any medical documents, lordship. And he cannot.
That is not enough. Bail after an order of conviction is something extraordinary. You have to make out an extraordinary case that the judgment has been is a perverse one.
Lordship, it's only on circumstantial evidence. No.
Circumstantial
eyewitness.
evidence, is it eyewitness a necessity for a conviction?
No, lordship.
Then what kind of submission is this?
And the facts, may I state, lordship?
No, first we have to come to a finding on the service upon the respondent number 2. Why does the jurisdictional police station report to you?
Because
You give him a telephonic instructions to the
Obliged.
third MSD goes. Madam, we'll have it on Thursday?
Thursday, Lordship, on
Yes,
first. Yes, Lordship.
first, yes. Third, MSD hosts learned counsel for the applicant. Also heard three, G Tado, learned additional PP. Arunachal Pradesh, full stop. Sindhi order dated 5/1/2024. Full stop. The last part of the order reads as follows, second last paragraph. Quote. Para. Office note dated 9/1/2024 reflects that the order was communicated to the learned APP, who however submits that instructions are yet to be received. Full stop. Para. This appeal is pending since the year 2022, which is against an order of conviction. And dependency till now is only on the issue of service. Full stop. It is strange as to why the requisite information could not be furnished by the concerned SP regarding service upon the SP number 2, in spite of the clear order of this court. Full stop. Para. As a last chance, comma, list this case as a last chance, comma, further opportunities are granted to obtain these instructions from the concerned SP, fixing first of first of February. Full stop. It is made clear that in the failure to get the necessary instructions, comma, this court would explore passing of appropriate orders, including orders of personal appearance of the concerned SP.
Deeply obliged, Lordship.
Obliged.
Deeply.
Yes.
Now, I'm appearing as a amicus curiae. Here in the last order, which was passed on 4/10, there direct the registry to take fresh step. That means the complainant, the person who wrote the affair, was to serve a notice. But the complainant is a Sumita Kobar. She is a floating labor. Since she is a floating labor, it will be very difficult to trace them out. Therefore, this matter may be posted for final argument instead of waiting to the return of the service.
We can have a legal aid counsel, I think.
Yes, Your Lordship, there are two addresses, Your Lordship. One is of Arunachal Pradesh and one, but the permanent address is of Assam, Your Lordship. The service upon, in the address of Arunachal, Your Lordship, it's shown as unserved. The addressee does not stay there, Your Lordship. However, the service to her permanent address, it's still awaited, Your Lordship.
You try as a last chance. In the meantime, we'll direct preparation of the paper book.
We have got the paper book, Your Lordship.
The paper book is already supplied.
Already supplied.
Yes.
Okay. Paper book. Okay. Okay. We'll try a last chance in the Assam address. Then we'll have this for hearing. And if she doesn't appear, we'll appoint legal aid counsel.
Yes, Your Lordship.
Okay, madam. Third, three, M14, learned senior counsel, who appears as amicus curiae for the appellant, full stop. As per the last order, it is 3/1/2024 of this court, comma, the service upon the respondent number 2. No, registry was to verify regarding the service upon the respondent number 2. Full stop para. Ms. Jenny, the learned additional PP, Arunachal Pradesh, has however informed that the respondent number 2, that there are two addresses of the respondent number 2, and the said respondent number 2 was not found in the address in the district of East Kameng, comma, Arunachal Pradesh, full stop. However, comma, there is another address in the state of Assam wherein the service may be attempted to be affected, full stop para. In view of the aforesaid submission, comma, let service upon the respondent number 2 be. Where is the second address? Okay. Respondent be made in the address in the state of Assam. Full stop. Registry is accordingly directed to do the needful for serving of notice through the concerned police station of the aforesaid respondent number 2. Full stop. List after 4 weeks along with service report.
Deep.
Great, Your Lordship. Well, in this case, I need to file affidavit in reply, madam, against the affidavit in opposition filed by respondent number 2 and 3.
Yeah, for 2 and 3.
Yes, my lord.
Who is one?
Chief Secretary. madam.
Chief Secretary, my lord.
Ratan for why not for
1, 2, 3, my lord.
1, 2, and 3. Who has filed the affidavit in opposition?
My lord, actually, in this case, my lord, our names are not shown in the cause list. Today also, our names are not shown.
No, we'll direct showing our names.
Yes, my lord, that will be my.
And
Okay, 1, 2, 3, 4.
Heard Sri I. Chaudhary, learned counsel for the petitioner. Also
Your
heard,
Lordship, I'm from respondent number 5.
also heard Sri N. Ratan learned AAG for the state respondents. And madam, your name?
B. Mema.
So instead for respondent number 5, full stop. It appears that the state respondents have filed affidavit on opposition, full stop para. Sri Chaudhary, the learned counsel for the petitioner, accordingly praised for and is granted 3 weeks time.
Yes, madam.
3 weeks time to file rejoinder affidavit, full stop para. Registry is directed to reflect the name of Sri I. Chaudhary
And T. Hussain, my lord.
and
T. Hussain.
T.
Hussain.
T. Hussain as counsel for the petitioner in the cause list.
Lordship.
You want a date?
No, not required.
Hmm?
If date is given, it will be helpful for us.
Yes, list on, tell us a date after 4 weeks.
4, 2, 1.
We'll have it on 27th. Is it okay?
27 February.
Tuesday?
Yes, obliged, Lordship.
May it please your Lordship.
Yes.
My lord, I have received the instructions. Apparently, my lord, that finding was there before the inquiry report was sent to the petitioner. Apparently, that was there. But he was given an opportunity to respond to that. And consequently,
No, that will not make any
my
meaning.
I have understood. My lord, then my lord has seen the admission on the part of the petitioner. I'm just making a
No,
substantial.
see, if you had wound up the proceeding,
Yes.
based on the admission, matter would have been different.
Yes.
You, on your own volition,
Yes,
you decided to go ahead with the inquiry. So that part of admission, now we cannot fall back. No, there was an admission, no, there was no
What-
requirement of
What
inquiry.
I am submitting is as a foreign from lordship to the last occasion. The disciplinary authority has changed now. The inquiry
No,
report,
even if it's not changed, in case we want, the liberty is already granted by
yes,
the
yes.
learned single judge.
Right.
And if you want to proceed, you can proceed, you have to proceed with another incumbent of the
Yes.
same rank,
Yes.
who can act as the disciplinary authority. That we can do. We can make our order very short also, based on your. Obviously, we'll observe that notice does not appear to be in the prescribed format, that whereby you had forwarded the inquiry report. You have already made up your mind.
Yes.
That part is a little bit, I do not know whether that's been taken care of in the single bench.
No.
Not
No.
taken care of. But nonetheless, liberty was granted to you
Yes.
to move. Where is the petitioner?
He's on through video conference. We can proceed, my lord, then.
Mr. Bhol, yes.
Yeah, I'm.
Yes, you heard the deliberations. Yes, we can give them the liberty. The liberty was already granted by the honorable single judge.
In the meantime, situation has been changed because the relation of employer-employee has been ceased. In view of the Supreme Court decision, now they
No,
cannot
sir,
initiate.
it is a continuous proceeding, and they are not proceeding from the.
No. I am going behind back because why the de novo inquiry was initiated? Because the de novo inquiry was given a liberty by the honorable court subject to satisfying two conditions. They have not satisfied both the conditions and inquiry is conducted. That is reflected in my writ petition. They have given a very contemptuous reply. I am coming to
That part of the order has not been challenged by
You
him.
have to challenge that order. You have
No,
there is
no.
challenge.
I am coming, Lord. I am not that on that point. I am coming, Lord. The de novo inquiry itself is on the basis of the liberty given by the Disciplinary Court. But the
No,
liberty was.
Mr. Bhol, we are not on the inquiry. We are on the stage after the inquiry.
Yeah, but I am coming, my Lord. I am coming. Why the de novo inquiry itself was de novo inquiry cannot be communicated, cannot be initiated without complying the orders passed by this. This liberty was
Then
given subject to.
you have to file an independent appeal.
Yes.
We have not done that.
No, that is how that was my contention before the writ petition, before the writ court.
That is it. Let us read the order of the honorable single judge.
Yeah, my lord. Order of the first order was at
Paragraph,
not the
page,
first order.
page 176, my lord.
The last
page
part,
67.
order.
the last
want
part
to
of
take
the
my-
order. We are only concerned with the order which is
Under
challenged
challenge,
for
yes.
us.
176, my lord, last page.
176.
That part he has not even put to challenge.
176.
Yes,
last
paragraph
part,
28.
Paragraph 28.
Yes. In the result, the petition stands allowed by setting aside the report of
No, no.
disciplinary proceedings.
I am.
Just a moment, I am
Sir.
reading. And the consequent order of punishment is such and such imposed upon the petitioner. In view of the setting aside of disciplinary proceeding and the consequent order passed thereon, the petitioner shall be reinstated in service with all consequential benefits. It is submitted the bar, the petitioner in the meantime retired from service. In such event, the petitioner shall be entitled to retirement benefits, which is legally entitled to. The respondent authorities shall settle all such issues within the period of 3 months. So it has been clarified that the judgment would not stand in the way of proceeding against the petitioner by the respondent authorities again if the same is permissible under the law. This part is not under challenge.
My lord, I am on the point. Why the de novo inquiry was initiated without complying the orders of the Supreme Court? Because de novo inquiry was subject to complying two
As a
conditions.
respondent, can you raise the point, Mr. Bhol? Tell us.
My lord,
As a respondent in the appeal, where is your petition? Where is your appeal?
My lord, my
If you are raising issues on the de novo inquiry, you have to come before the court.
Yeah, but that
You
is
have
how
not
that
come.
is my.
Sorry,
my
sorry,
lord,
we are not going to. On this, we are not
My
going to.
lord,
hear you.
I will take also two paragraphs of the order and my contention and the
Mr.
reply.
Bhol, as a respondent, you can make your arguments in this appeal. We are not setting aside the judgment of the honorable single judge. We are, in fact, confirming it. The last part of the judgment says that there will be a liberty. We are only saying something more in your favor, that the second show cause notice does not appear to be in terms of law, and only from the stage of second show cause notice, they will proceed. They have the liberty to proceed. We will not direct them to proceed. It's their choice. And if it's done, it has to be done.
It
through
is
another
it is
another officer.
already there in the order of the in the imposed order. They could have,
We are not interfering with this order, so no point hearing it. Okay, we'll pass the orders.
if your lordship permit me, if your lordship permit me within a.
We are dismissing this appeal. What else do you want to
Oblige,
say?
oblige, madam,
Okay.
oblige, madam.
Oh, heard. Sri D. Pangi, learned counsel for the petitioner, for the appellant,
Appellant.
who has preferred the appeal against the judgment and order dated so and so and so. Also heard Sri G. Bhol,
Yeah, my lord.
G. Bhol, learned counsel who has appeared through video conference. Full stop. Okay, we'll pass the detailed orders in the chamber. Okay.
Madam, may I submit one thing? Related specific date may be within that time. If they want, they will conclude. If
Yes.
they want, they will, your lordship may pass some orders finishing the date within a specific date so that it can
Yes,
be
yes.
completed. If they
No,
want.
now we'll specify that the directions which were in your favor in the judgment to settle your dues, that has to be done. That will
Yeah.
do.
Okay.
Okay.
Oblige.
May I please, your lordship? This appeal has been filed, lordship, against the order of the learned single judge judgment dated 25/8/2023 in WPC 7. Your lordship has been apprised on the last date.
Yes, Mr. Kato,
My lord,
present selection, what is the status?
my lord, officer has come along with the, my lord, the original record, my lord.
No, no, you.
My lord,
we
it is
don't
under,
need the presence of
under
the
process, my lord, not yet conducted the, my lord, the interview. As per the, my lord, instruction, only, my lord, call letters, my lord, selection, screening has been done, my lord. Call letter is also not yet issued.
What was the reason for cancellation?
My lord, cancellation, my lord, what happened after advertisement? The interview was conducted at Shillong, my lord, and the main recruited for the, my lord, institution at Pasigat, my lord, and it has been controlled by the, my lord, ministry at Delhi, my lord. And, my lord, after conducting the examinations by the center at, my lord, Shillong, they send the, my lord, the copy of the, my lord, entire things in open, my lord, manner.
Email you have
Email,
said.
my lord.
Yes.
And by that way, my lord, she came to know also, my lord, that regarding the, my lord, the selection, my lord. My lord, that was the confidential that has to be sent to the, my lord, the, my lord.
Have you alleged any malafide?
No, lordship.
Then what are your grounds of challenge?
Firstly, lordship, in the communications, initially they have said change of nomenclature. Change of nomenclature.
Regarding?
The name of the institute.
That is not that cannot be.
That was their ground in the communications which they have annexed in the reply, in the affidavit in opposition. Later on, they have said that because because that letter was open.
Let us have a look at the order of the learned single judge.
Lordship, page 34.
3-4.
Yes, para 9. This is the lordship, the operative portion, lordship.
3-4.
Yes. Para 9.
Yes.
When the matter was taken up for hearing on 18/8/23, this court, upon finding a mention about a letter dated 4/3/2021 of the respondent number 4, respondent number 4 is the director of the institute, to the Ministry of Ayush in communication dated 1/4/2021, asked the learned DSGI to produce the same. Accordingly, the learned DSGI has produced the said letter. On a perusal of the letter written by the respondent number 4 through its director to the Deputy Secretary to the Government of India, Ministry of Ayush, goes to show that it is regarding certain queries sought from the respondent number 4 by the ministry. The question raised was as to why the result of the examination, written examination / skill test was opened by the institute without placing the same before the selection committee. The reply to the query is that the results of the selection process conducted by the respondent number 3, that is the director at Shillong, was sent by the respondent number 3 to the respondent number 4 via email. As the communication and attachment was addressed to the director, there is respondent number 4 institute, director respondent number 4 institute, the same was opened by the director. Therefore, it appears as the communication was sent by email, the same lost confidentiality, which was one reason amongst others which prompted the issuance of the instruction not to proceed with the process of direct recruitment. Now, Lordship, it appears Lordship may once go through the letter dated 1/4/2021. In which this mention has been given, Lordship.
Page?
That, Lordship, is at page 125.
125.
Yes, this is a part of the affidavit in opposition filed by them. This is the letter mentioned. That means the letter in which that letter 4/3/21 was mentioned. This is written to the director at Pasigat, Northeastern Institute of Folk Medicine. Subject is conduct of written examination / skill test fulfilling of various posts. Sir, I am directed to refer to your letter dated 4/3/21 on the subject mentioned above and to say that the matter has been examined in the ministry. A proposal to change the mandate and nomenclature of the institute is under consideration by the government. It has been decided not to proceed with the process of direct recruitment at this stage. However, for existing employees, DPCs may be held. So this is the communication by the ministry to the director at Pasigat. This is the first reason they say was the reason why that selection was cancelled. Now, Lordship may come to page 130, Lordship. 131, sorry, 131. This is also a communication written to the director. This is 2nd August 2022, written to the director by the ministry. Here it is said, sir, I am directed to refer to your email dated 25/7/2022 on the subject above mentioned and to state that the competent authority has approved your proposal.
And due to some other procedural infirmity.
Yes, yes. Now, Lordship, the letter which was referred to by the learned single judge, that was placed only during the time of the hearing. So we don't have a copy of that. So we don't know what is there. But it transpires from the para 9 that it was a communication about the written and skill test, Lordship. That was sent to the director. Why will he not open? I mean, it is sent to the institute, to the director. How has that result in loss of confidentiality? I don't understand, Lordship. Now, Lordship, because that result, Lordship, which is at page 120, Lordship. This is also part of their affidavit opposition. It is not as if there was anything else to be done in the result. This was a final select list, Lordship. Page 120, Lordship. Part of the annexure of the respondents, Lordship. The result was sent by the director at Shillong to the director at Pasigat, Lordship. And this is a final selection list, Lordship. Has my Lordship found 120, Lordship?
Yes.
In reference, this is dated 24/3/2020.
What is your name?
Mine is Lek Mego, Lordship. Your Lordship may find my name in page 121.
Next page.
The next page after that, 121. The second page is a type copy, Lordship. Lordship, in reference to your letter dated this notice of this office notification dated this, Shillong has successfully conducted the written exam / skill test on 19 to 21st February 2020 for filling about various Group C, Group B and C posts at NEI FM Pasigat. Based on the marks obtained by the candidates in the written test / skill test, the marks list and the marks and list selected and weighted candidates against the respective Group C and D are as under. So this is the select list, Lordship. So initially, Lordship has seen page 125, Lordship, that
No, unless the cancellation is done, Malafide, you have to favor somebody, a particular candidate.
yes,
Can you
Lordship.
challenge it? Do you have any indefensible right?
No, that I do not. I admit that,
And
Lordship.
if we see from the records that there are reasons for cancellation, of course, cancellation cannot be done at the expense of the public exchequer because one selection takes a
Yes.
lot of expenditure. But what are your reasons in the records?
My lord, basically, my lord,
Records.
my lord, records, my lord, all the relevant communications made.
Where is that part regarding the leakage part or coming into the domain of public domain? That
Yes, my lord. As per the, my lord,
intermediary part.
my lord, as per the recruitment rule, my lord, it has to be first place before the selection committee, my lord. But directly made, my lord, they, my lord, made public by, my lord, the selection committee of the Shillong, my lord, the interview conductor. My lord,
It was actually, Lordship, not made public. It was given to the director. It was not published, Lordship. It was not published. I came to know only because I happened to work in a temporary capacity in that office.
If it was not published, how did you come to
my
know?
lord, that is.
No, that's because the then director had told me only that, Lordship. Otherwise, it was not. It was not.
Then you have to make out a case that you have a right.
Now, Lordship, just one point, Lordship. In page 125.
125.
Yes, 125. I already read out.
Yeah.
This is in total contradiction with page 131. I'm saying this because, Lordship, this letter has been written by the ministry to the director saying that we have decided to not to go ahead with the process.
This you have already 2021 you have already.
Yes, Lordship. What I'm trying to say, Lordship, is the ministry has said by this letter that a proposal to change the nomenclature has been, so it has been, is under consideration. Therefore, we are deciding not to proceed with the process of director recruitment. It seems that the decision has come from the ministry, Lordship. But Lordship, we'll see page 131. Same ministry has written to the same director saying that we have approved your proposal. It's not even clear who has made the proposal, Lordship. And initially, by this letter, although that letter dated 4/3/21 has been
What are
mentioned
you trying to say here in 131?
in 131,
Yes, 28.
if when we read 131, it appears that the proposal to cancel the recruitment has come from the director and not from the ministry, Lordship.
And a competent authority has approved.
Your
your
proposal.
For cancellation.
Yes, your proposal.
Initiated by so and so for recruitment.
Your proposal meaning the director, Lordship.
Change of nomenclature. Reason specified by you. Where is this? This is in context of which letter, Mr. Kato?
My lord,
This communication at 131, 2nd of August 2022. Where is 25/7/2022?
That has not been annexed, Lordship.
Do you have that letter, 25/7, email, 25/7/2022?
25/7, my lord, I'm sorry, my lord, this copy, my lord, instruction has been received by me.
It will be there.
25,
It has to be there. It's in connection at 25/7.
25/7, 2022.
These are the letters, no? I have received from the ministry to dispose of the matter. These 3 letters. You can see based on this 1-4. Again, 1-4. This is in reply to various grievances in the ministry. So based on this was
25 later, one second. Which one is better?
which one I haven't seen. Which
What's the difference? 24.
You mentioned, Jasmine. 25/7/2022. Email, page 131.
This letter.
it's consideration. Second number. Can I check here? This is for consideration. This is very important. This is
In the meantime, my lord, since they are taking time, may I point out something, lordship? After that selection, according to the affidavit, after that select list was sent, received, the director had apparently written to the ministry on 25 March 2020. This is at page 121, 124, saying that we have received a copy of the result. As such, you are requested to kindly approve the recommendations and allowed undersigned to take further action for appointment of the selected. So what was required to be done was only the recommendations were to be approved and appointment was to be done.
Where is that?
Page 124.
124.
Yes, this is a part of their affidavit. So they're saying that as if there is another selection committee. It is not that, lordship.
No, this is of 25th of March 2020.
Lordship, what I'm trying to say is they had said that because the results were open, so confidentiality has been lost and everything before being allowed to be placed before the selection committee. Lordship, there is no other selection committee, lordship. As per this letter, only that select list was to be approved and appointment was to be made, lordship.
Now we have to have a look at the corresponding communication, because this is of 25th of March 2020.
Yes, of course,
And
lordship.
the 2nd of August 2022 letter
Yes.
refers to an email of 25/7/2022.
Yes, lordship.
That I think will clarify everything. Now you come to page 125 of the,
131, lordship, that letter.
oh yes, 131, yes. 131.
25 July 2022.
Come to 131 first. Please read the letter. First line. This is from the ministry. Director, I am directed to refer to your email dated 25/7. We want this email. This 25/7. First line, read the first line. I'm
directed to refer to your email, dated 25/7.
Yes, this one. Where is this?
On the subject mentioned above, to state the capital authority will approve your proposals for the execution of the recruitment process of the district by being so of the recruitment to there is 25.
That means on 25/7 there was a proposal. No, you will have a printout. Soft copy, you can take a printout. What is the difficulty? No, otherwise do not find much of merits in this appeal, because decision is yours And unless malafide is alleged or made out that it is only to oust her and to accommodate somebody else, your decision to cancel might be for any other reasons. We may not interfere. But since you have referred to 25(7) as if it is a proposal from the directorate itself to cancel, we want to look at the proposal. No, we are not on the other communication. See, this 2/8/2022 at 1:31 is a very crucial communication. It says that they are acting upon a recommendation, a proposal by the directorate via email of 25/7/2022. This was what was required. When can you get the copy? When can you get the copy? No, when can you get it? Monday. Will you have it on Monday, madam?
Lordship, I'm sorry, I'll be out of station, Lordship, since.
Tell us the
tomorrow.
date of your convenience. Wednesday? 7th? Or 9th, 8th, 9th, anything?
7, Lordship, 7,
7th is okay for you?
yes.
7th February? Okay.
Right, otherwise, it shouldn't take more than 10 minutes to take on an email, Lordship. And can it be taken after some time? Let them try, Lordship. He's not going to take the email from Pasigat, Lordship. They'll know the email address.
No, he did not go back to Pasighat. She is also correct. He can have a communication with his office and they can send a print or WhatsApp or whatever, email and get a printout. Last.
There is one more item, Lordship, so
Okay, we'll have it on Wednesday next day. Okay, get the instructions.
oblige.
Third, Miss the and learned counsel for the appellants. Full stop. The learned counsel, by referring to our communication dated 2/8/2022 of the ministry, has submitted that the said communication refers to an email dated 25/7/2022, which appears to be from the directorate, whereby a proposal for cancellation of the recruitment process was given.
Email letter.
However, full stop. Also heard 3M Katu, learned deputy SGI. Full stop. What is your name?
Robindra Teran.
You are as,
I'm a director.
you are the director?
Right.
Dr.
Sri-
Ravindra.
Dr. Rabindra Terang, Teron, the director of so-and-so, is also present with the records, full stop. However, on examination of the record, copy of the said email dated 25/7/2022
Right.
is not readily available, and therefore some more time is sought for. Full stop para. In the interest of justice, list on, in the interest of justice and as agreed to by the parties, list on 7th of February.
Right.
Oblige.
Developed.
May I please, Lordship?
Yes.
Lordship, in this case, my senior will argue on video conferencing from Guwahati.
Yes. Mr. Ghosh, you are there?
Yes.
Yes, my lord.
Yes.
Lordship, in this case, my lord, we have seen a judgment of the Honorable Single Judge of 5/7/2023, my lord. That my lord will find at page 322 of the appeal memo, my lord. Now, here in this case, my lord, the respondent number 345 herein, the private respondents, they have assailed their promotion to the post of the assistant engineer civil, lordship. DPC was held on 7/9/2020.
Let us read
for-
the, let us read the judgment. It's come for admission.
Yes, my lord. The judgment is a bit lengthy, my lord. But it starts from, my lord, page 323, my lord. Enter. My lord, may I read,
Yes.
my lord? My
Yes.
lord. My lord, by this read petition, the petitioners, three in the numbers, who have challenged the recommendation of the Departmental Promotion Committee, DPSC, dated 7/9/2020, and the consequent order dated so and so, whereby the service of the petitioner has.
You are not parties in that, you are not parties in
No,
that.
I am not in the parties in the petition. My lord. They have given the retrospective promotion from 2006, my lord. 3 and 4, 5, my lord. And they
Now, have
gave-
you sought, have you sought leave to file appeal?
Yeah, our leave has been granted, my lord.
Leave has been granted, okay.
Yes, my lord. Because by giving them the retrospective promotion from the date of their officiating promotion, whether I should say it's a fortuitous promotion to the post of assistant engineer, whether rehearse the role, my lord, our seniority is going to be tempered. That is what the case of the petitioner also before the Honorable Single Judge, my lord. And that's what the department also going to do. So our prayer is that, my lord, we should be allowed to participate in the proceeding. Let us have a stand in the matter, my lord. And then the matter can be decided after hearing all the stakeholders here, my lord. If anybody is aggrieved, they can file a writ appeal further, my lord, in this case. This is my humble submission. They will be not prejudiced, but will be prejudiced, my lord. Because we are already in the senior India gradation list of the assistant engineer. They are much below to us. If your lordship kindly look into, my lord,
Mr. Ghosh, that's very easy for you to make that argument.
But
But see, this writ petition was filed in the year 2021.
21.
The judgment is of 2023 June.
Yes.
You were sitting on the fence watching the proceedings. It's not the case that you are not aware of the matter. You were in the same office. You never came up for an implement. We are not finding favor with the petitioner that they have not joined you. They have not joined you. That's their prerogative. If they had not joined you, you could have come for implement. After you waited till the judgment, there's a delay condemnation, then suddenly you woke up and you come to the court. Delay has been condemned, that's a different matter. But at this stage, can you say that no, the entire matter has to be reheard, giving us an opportunity? What were you doing at that time? 2 years.
Actually, my lord, we are not agreed with the DPC because DPC, they have given the
You knew about the litigation, that there's a litigation by some of them who are seeking promotion from retrospective effect. They have not been given, but now they have also filed a writ petition for retrospective effect. That's a different matter. Now this order, we can at best admit this. We can admit this, but there's no question of any.
In fact, they were aware of the pendency of the writ petition matter. During pendency of the writ petition matter, provisional seniority list was published, madam. And in the remark from Lordship, kindly for a moment take page 89 of the 89, my lord.
Yes.
Seniority list was published in the cadre of my lord, assistant engineer, my lord.
You are seeking to be which post are you seeking to be?
Assistant engineer.
Assistant engineer.
Yes, madam.
And what is the post you are now holding?
Assistant engineer still.
You want retrospective effect?
Yes,
To
madam.
the promoted post of assistant engineer?
Yes, madam. We were
That is
granted
the cause of action in the writ petition filed by you?
Yes, madam.
Which is the writ petition, WPC?
WPC, my lord, 297 of 2023, madam. Just to show that, my lord, pendency of the writ petition, they were aware of the fact that, my lord, writ petition was pending. Lordship,
Now we can admit this. We can admit this. We admit this, Mr. Ghosh.
Lordship. দাঁড়াও না, আস্তে আস্তে।
Heard Sri Ghosh, the learned counsel for the appellant. How many of you are there
13 mile, 13 mile, 13 April.
for the
Appellant.
appellants? Who have put to
14.
challenge,
Sorry,
who
Lordship.
have put to challenge a judgment dated 5/7/2023 passed by the learned single judge in WPC 297 of 2021. Full stop. It is submitted that though the present appellants were not party respondents, comma, they have, a leave has been granted to them to file this appeal. Full stop. This court has also noticed that while an order dated 22/1/2024, comma, the delay in preferring the appeal has also been condoned. Full stop. Para. It is the contention of the learned counsel for the appellant that in the adjudication process, comma, they were not given a fair opportunity. And by the impugned judgment, comma, their seniority in the cadre of assistant engineer is likely to be adversely affected. Full stop. Para. Sri R. Saikya, learned counsel for the opposite parties, writ petitioners, has however contended that the appellants were all along aware of the writ petition which was instituted in the year 2021.
Malay, dispute that submission. my lord.
No, his submission.
Yes, my lord. Yes.
And the judgment was delivered only in June 2023. And the present appeal has been filed thereafter, comma, that too, with a delay. Full stop. He further submits that on the issue of not giving retrospective effect to the orders of promotion, comma, his clients have filed another writ petition WPC 297 of 2023 in this court. Full stop. Para.
297 টা কোনটা?
Three, Ghosh, learned counsel for the appellants, however, disputes the aforesaid submission that his clients were aware of the writ proceedings. Full stop. Para. Be that as it may, comma, the
Read question.
issue involved would require some deliberations. Full stop. Admit.
Why 27?
Para.
Data 37.
Records.
Madam, here, the appellants were not party to the writ proceedings.
They have been granted leave.
Yes, madam.
They have stated already.
And affidavit of the state respondents. I believe that also has not clearly reflected the
Yes.
factual positions.
But,
Yes.
We'll hear it.
Yes.
My lord, the thing is that, my lord, the earlier judicial proceeding in the court, the court has found that there are no vacant post available in the promotional quota, so as to give them a retrospective promotion, my lord.
Okay,
And
we'll
this-
we'll examine that, don't worry.
My lord,
my-
Sri-
my lord,
And they are all
We are not
junior
saying anything
engineer.
else now.
Well,
Why
I-
is
they
it
are-
already?
And they are
We are
all
not
my lord,
passing a
junior
final
engineer,
judgment, we are just calling for admitting it.
my lord.
Sri N. Ratan Learned AAG, Arunachal Pradesh accepts notice on behalf of responsibles
1 and 2.
1 and 2, whereas Sri R. Sekya, Learned Council is present for the responsibles 3, 4, and 5. Full stop. Since the present appellants were not made parties, and their stand is reflected only in the memo of this appeal, the respondents are at liberty to file affidavits in this case.
Yes, madam.
My lord, the
Sir,
status
list of
with regard to the seniority position may be maintained at this stage. Yes,
no,
ma'am.
They are also filing a writ petition, list after 4 weeks, full stop. Any actions taken pursuant to the judgment of the learned single judge would be subject to the final orders to be passed in this appeal.
আমরা ওগুলা ফাইল করছি detail. Huh? Subject to the outcome of the decision.
Making a prayer as the DSGI
My lord,
in all these matters.
my lord.
लिख लिया ना 2, 3, 2, 3 एक ही होगा
4 also, my lord. Sorry, 5.
4,
Oh, sorry,
5 is not there
5 is not. 6, 7, my lord.
6, 7, 6 and 7 एक order होगा 32. Sri M. Kato Learned DHJ prays for some time to obtain instructions. Full stop para. List after 2 weeks.
My lord. And my lord, subject to my lord, the consent given by the other party, my lord, for my lord, here 32, item number 32, my lord.
32 we have already mentioned.
My lord.
32 is what? Yesterday's matter.
Yes, my lord. I'm sorry, my lord.
If you want to give some time, then I can finish it in 5 minutes today.
Now why you are seeking time this?
My lord.
Why?
My lord, I haven't gone through the records, my lord.
Which record did you go through last evening? You're mentioning, you're adjourning all the matters.
No, my lord, there are other matters also, my lord. Item number, my lord, price item, my lord, 18, 19, 20, 21, my lord. And 23 is also, 25 is also there, my lord.
No, madam,
25
you
is,
cannot go do in a piecemeal basis.
my lord.
Hearing your part and his part.
My lord, in that
If
case,
it
my lord.
goes in
Deeply obliged.
May lordship.
Yes,
I beg to mention item number 8. Item number 8.
8, yes.
Lordship, we may allow some more time to file affidavit in opposition. The standing counsel for the respondent number 2.
Tourism department,
Yes, sir.
tourism. Inform
Yes.
the respondent petitioner's counsel
Yes. Respondent number 2.
on a prayer made by Sri, your name?
J. Apum. J. Apum.
Yeah, Pum, learned counsel appearing for the tourism department. Matter is adjourned by 2 weeks to enable filing of affidavit in opposition.
May I please, Your Worship, I'm on behalf of petitioner. Kindly, short date may be given.
2 weeks we have said, 2 weeks.
Oh, okay.
2 weeks. Is there any interim order?
They have to file affidavit.
Is there any interim order?
No.
Okay. Should we give a date? After 2 weeks? You
It's
want a
okay.
date?
No, it's okay.
No, if you insist or if you want, we can give you a date.
We have given him already consent. So,
No, if you want a particular date, we can give it.
no, it's okay.
2 weeks. Okay, next.
May Lordship. Lordship, I beg to mention item number 23. I'm appearing on behalf of the leading counsel of respondent, Mr. K. Tari. He is currently out of station.
Okay. Inform the petitioner.
Yes, we have taken the
How much
consent.
time?
23.
Lordship, for the petitioner, Your Lordship, here the pleadings are completed. We have already filed affidavit in reply. So this matter may be listed for admission hearing. After 3
After
weeks.
2 weeks?
Yes.
After 3 weeks, Your Lordship.
3 weeks, okay.
Lordship.
23, pleadings are complete and the matter can be taken up for admission. Full stop, para. List for admission after 3 weeks.
Obliged.
Obliged.
As prayed for, list for admission after 3
In
weeks.
the meantime, Lordship, we'll file, our affidavit is ready.
Then how is pleadings complete?
Lordship. apply करेगा.
Lordship, we could not,
We cannot say pleadings are complete.
Lordship in that Lordship. Then after 2 weeks, Your Lordship, for filing.
Don't write like this. You're for whom?
I'm for the petitioner, Your Lordship.
And you're for?
Respondent.
Your government is yet to file the.
yes, Lordship is ready, we are
Okay,
looking for.
okay,
the-
don't write like this.
public service. book.
Though the private respondent, you're for the private respondent?
Yes.
Has filed affidavit in opposition followed by a rejoinder
Yes, Your Lordship. we
by
have
the
already filed.
petitioners,
Lord.
comma, the official respondent number 1 is yet to file the affidavit in opposition. Full stop, para. List of the 3 weeks to enable filing of affidavit in opposition by the respondent number 1.
Obliged.
Yes, sir.
Deeply obliged.
पहला वाला नहीं रहेगा, admission नहीं रहेगा.
May I please, my lord? My lord, I beg to mention item number 16, my lord,
16 years,
on behalf of White Dollar, my lord.
yes.
My lord, we need some time to file affidavit in opposition, my lord.
On a prayer made on behalf of the all the respondents,
No, my lord, only respondent number 7, man.
behalf of respondent number 7, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. What about the other respondents? Don't fight.
My lord, I don't have idea, man.
Office not to file. Office may also reflect the status of service upon the respondent number 9 by the next date.
My lord, can it be taken on 22 of February, my lord?
As requested, list on 22/2.
Yes, obliged.
May I, your lordship? Your lordship, I beg to mention item number 12 on behalf of conducting counsel P.K. Tiwari. With the consent of the other party, matter may be fixed, your lordship, on 12th February.
Okay, you're for the petitioner?
Yes, your lordship.
On a prayer made on behalf of Sri P.K. Tiwari, learned senior counsel for the petitioner / applicants list. Matter is adjourned to be listed on 12/2.
Yes, your lordship. Much obliged.
Yes,
My lordship, I like to mention item number 25.
25 years.
Yes, your lordship, petitioner counsel is out of station. So.
Who is out of station?
H. Lampu,
Okay.
2 weeks maybe time given.
18 matter,
Yes.
2018 matter, where in 2024, how many years?
So I'm for the respondent sides. The petitioner counsel is out of station.
Okay. You're for the respondents?
Yes.
What is your name?
L. Tatam on behalf of land department.
Sri, your name? L?
L. Tadam.
L. Tadam?
Yes.
Learned counsel appearing on instruction of Sri D. Kamduk. Learned standing counsel, land management department
Yes.
submits that he has been informed informed by the learned counsel for the petitioner, Sri H. Lampu, regarding his non-availability. Full stop, para. Considering that this matter is of the year 2018, comma, a short adjournment is granted directing listing of this matter on 9th of February,
Okay.
9/2.
Much obliged.
May I, my lord? This is a tender matter, my lord. What happened, my lord? The instruction was called for.
My lord, ground of rejection is there in the affidavit itself, the declaration which he made. The tender was issued by the executive engineer, not the chief engineer Arda. So on that ground only, his tender, technical bid was rejected. May I take the
Where, page?
397, my lord.
390.
They are
Three-
admitting my affidavit, my lord.
397.
Yes, ma'am.
His declaration.
Yes,
Issued by the chief executive officer, CEO Arda Itanagar.
yes, what is there?
Then second affidavit also, he has made same mistake.
No, no, no. What is the problem with this affidavit?
No, tender was issued by the executive engineer, not the chief engineer. The document which SBD,
Okay, okay.
page 39 also, is issued by the,
397.
yes.
Where is the tender? 39. Where is the NIT?
NIT
my lord.
is,
Page?
It starts from, my lord.
Where do you get chief engineer or executive engineer?
That's the, that is the, my lord, it is in the corrigendum, my lord. Page
Page-
135.
135.
Yes.
Yes.
chief engineer, employer. That does not mean who issued the tender. Tender can be issued by the tender was issued by the executive engineer. In case of
No, no,
demand draft,
How does it substantially make any difference
Yes.
in your understanding?
my lord,
No, in the
the
affidavit,
executive engineer is the employer of the government.
understood.
Yes.
We are 100% with you.
Yes.
But he wrote chief engineer. Is there any difficulty in understanding for which work this affidavit has been given?
No, tender was issued by the executive engineer.
Are we saying no?
Yeah.
But in the details of the tender mentioned in 397,
Yes.
is it difficult for you to discern as with regard to which matter this affidavit has been given?
My lord, it make altogether difference. Since tender was not issued by the chief engineer, that is what the technical committee has decided.
I don't think this is a good ground.
In other
You are reducing competition ultimately for this trivial kind of matters. If the tender number was different, date was different, and you have a corrigendum which says the name of the employer may be read as, so instead of executive engineer, everything has become changed. What is the meaning of this corrigendum at 135?
the corrigendum, in case of demand draft, it has to be in the name of the employer, that is Arda, chief engineer.
Chief
Chief
executive. officer.
executive Arda.
Yes. chief
Demand
executive-
draft, it has to be. But tender was issued by the chief executive engineer. That is the issue.
What is appendix reference 1.1 of SBD?
Well, that would be at page 103, my lord.
103.
Yes, ma'am.
103.
Yes, madam.
What is this at
My lord.
103?
Contract data to general conditions of contract, ma'am. clause one, my lord,
The clause one is employed in the government of Arunachal Pradesh.
through executive engineer.
Designation, it was changed by,
No,
Origin.
that particular clause, where
Yes,
is it?
clause one, my lord, clause 1.1, my lord.
Where is it?
In the one also, it said, my lord, serial number one, the employer is government of Arunachal through clause 1.1, my lord. Designation executive engineer, my lord, address is.
I don't think this is a good enough ground to disqualify.
my lord, other bidders, all they have written
Okay.
issue by the executive engineers. Since,
Not all. my
chief
lord.
engineer has not issued the tenders.
My lord, this respondent number 8, my lord, page 401, my lord, he has also met.
Neither in his interest nor in your interest.
Yes.
Well,
If you are
now,
supposed
as,
of considering, directing his bid to be considered, then the matter public interest will not suffer.
since the financial bid has been open, if this is interpreted, there would be must be press tender
Why?
because already financial opened.
His financial bids were given in seal cover,
Yes, my lord.
No, he was rejected in technical bid.
but both the packages have to be given at one point, at the simultaneously, same point of time.
Yes, yes, my lord.
It is with you, open it.
Yes, yes,
If you find that he is less, reject it.
Yes.
Gone.
yes, my lord.
No, he have not qualified in technical
No,
bid.
no, we will interfere with this. You hold him to be technically qualified, you still have the liberty
Discretion,
to
yes.
find other ground,
Yes.
take other ground.
Yes.
But on this ground, you cannot hold him to be technically disqualified or non-responsible. Then you open the financial bids, compare with the others.
Yes.
If he does not, if he cannot compete, he's gone otherwise.
Yes,
If he can compete, it is for your interest, public interest, less money.
Now, what I am told is that it will be difficult to open his technical at this stage. That
Why
is,
difficult? There are hard copies, there are soft copies, open it.
yes.
Don't go for fresh tender.
this, according to me, this is a substantial ground to reject.
No,
Since
No, we'll record your submission. We'll give our findings. We'll not give this pending. Heard. Sri B. Picha,
Right.
learned counsel for the petitioner. Also heard. Sri G. Tarak, learned standing counsel, RWD. Full stop. Para. When this matter was taken up on 24/1/2024, comma, the following order was passed. Full stop. Para. Today, Sri Tarak has submitted that he has obtained the instructions. Full stop. Para. The instructions. Full stop. The learned standing counsel, by referring to the affidavit which has been annexed to the writ petition itself, has submitted that the said affidavit annexed in the writ petition itself as annexure, as a part of annexure 8 series, has submitted that the affidavit itself was defective. Of the learned counsel for the petitioner as M.K. Neob instead of M.K. Doctor.
So let's listen.
May I plead, my lord? My lord, 29 relates to non-payment of compensation, my lord. The land was acquired for the construction of 132 kV rowing Teju transmission. So around 57.82 acres were acquired from the petitioner, but then the compensation was not paid. Because-
Compensation, acquisition was under which act?
Malad, they have not followed even the act, Malad. Whereas there is a clear notification issued by the government saying that even for the power project, it has to be acquired under the Land Acquisition Act. It is their own notification, it is available.
No, if it is only for the right of way, why acquisition?
Malad, I will just take to the notification, Malad. It's just very clear, Malad. It has to be acquired, Malad.
This 57.82 acres of land were taken away by them.
Yes, Malad. They have admitted, Malad. I will just show that.
One plot of 57 acres.
But it was, Malad, commercial plantation area, Malad.
No, one plot of 57 acres.
No, it's eight locations, Malad.
8 locations.
8 locations. For erecting the towers, 132 kV transmission tower.
It's not called acquisition.
Because
if it is for a power plant or something that land has been acquired, the matter is different. You don't get right of way. Right of way is for construction, erection, stringing. 3 elements are covered.
But the assessment was not that, Malad. They have not assessed even the property attached to the land. They have not even the attached.
That your entitlement or compensation, that we are not making any comments. You may be, but it's not an acquisition of land.
But in other place, Malad, they have acquired, Malad. In the
It's up to them if they've acquired under a particular act. Otherwise, for the transmission line, it is construction, erection, and stringing. 3 things.
Yes. But they have
Even if the wire, while at the time of stringing, passes through some area where trees have to be cut,
Yes.
even they will get compensation. Where
Yes.
there is no element of any acquisition of land. But where the tower is constructed or erected, the few parts of the
No,
land is taken away, but for that you are given compensation. That's a different matter.
tower.
But it's not an acquisition.
But then, Malad, there is also own notification. It says the power project
You
means.
get the instructions, will issue notice.
Well, this state notice may be issued, my lord. Another problem, my lord, there is a communication from the deputy commissioner,
Right.
my lord, to the division of forest. But asking for clarification whether it's a private forest or a government forest, my lord.
Okay.
Because some areas they are claiming is a private forest.
Okay.
So that doubt is
Okay,
there.
wait.
So forest
Third
department
three.
is.
S. Mao, learned counsel for the petitioner who submits, who has approached this court with a grievance of non-payment of compensation for compensation pertaining to 57.82 acres of land along with trees and properties. Full stop. The petitioner is also claiming solatium and interest. Full stop. The said claim is in connection with installation of tower for 132 kV power grid line Rowing Dash Teju in the Danglat village, Lohit district.
69 and 70 shows the locations, Malad.
Full stop. Para 3. R.H. Nabam, the learned AAG, Arunachal Pradesh, however, submits that firstly, it has to be ascertained as to whether the lands were private lands of the petitioner or government land, wherein forest was government land with forest, full stop. He further submits that erection, construction and stringing of electricity line may not per se amount to an acquisition. Full stop. Para, be that as it may, comma. Let notice be issued, returnable by 6 weeks. 3. Nabam, the learned AAG, accepts, Union of India is there. Who's that?
Mr. Kato, my lord.
Is it
I
there in
voted
the, is it there in the court?
Malo Kato, you were there, Malo, this court.
Sri M. Katolanit, DSGI, accepts notice on behalf of respondent number one. Comma, Sri D. Kamduk, Learned Standing Council, Land Management, accepts for respondent number four. And Sri Arish Nabam, Learned EAG, for respondent number six.
Six, my lord.
Para, let extra copies of the writ petition be served upon the learned council by tomorrow. Para, let steps be taken for service of notice upon the respondents 2, 3, and 5 by registered post with ED. Steps within 3 days.
Malo, as I reflected, my lord, there is a communication from the deputy commissioner to the divisional forest officer, malo, seeking clarification, my lord. Malo, so divisional forest officer is a necessary party, malo, he has implemented.
Arish Nabam has reported the Likhata. He has also raised the issue of non-joinder of parties.
My lord.
As a communication has been annexed in the writ petition itself.
Yes, my lord.
Yes, my lord.
Wherein the involvement of the forest officials is apparent.
Apparent.
Obliged. My plane, my lord. Item number 30 is relates to termination order, my lord.
As
He was working as a LDC.
LDC.
Yes, my lord. He was working since 2021. After 2 years.
Same,
my lord. Illegal appointment.
You said that only TGT and.
My lord, same.
primary- and did,
They have
Under
clapped
same
with the TGT and with the
yes,
teachers
yesterday
appointment.
you have That comes from another.
Entire investigation is also going on.
Graduate teacher, primary teacher, this is LDC.
LDC, my lord.
One person.
Yes, my
My
lord.
lord, only one person.
Same one.
And my lord, he was appointed on not on compassionate ground, my lord. My case is completely different from
We have
that.
not said
No, no, madam.
compassionate, okay, yesterday, his name, okay, Esma, Titagu. For,
For 2, 3, and 4.
and one,
One,
madam. Okay. One, Titagu, 2, 3, and 4, Titagu. Okay, list along with same order will go.
my lord.
It takes step, give extra copies.
Not obliged.
Yeah, please, all right.
Yes, 31, what is this?
My lord, 63 numbers of petitioners are before your lordship for compensation of Zeras, my lord, for construction of.
What is the stage now?
Is complete, my lord. The road is
We
complete,
have
my lord.
already filed affidavit, madam. And contending the, madam, the,
Last time I think you had contended because we have a note
madam,
which says that 1,32,30,000 has been paid
correct,
already.
madam.
It's a compensation of land, my lord,
Land.
not of Zeras.
Jirat, you are paying for
My
Jirat.
lord, my lord,
Now, if the pleadings are complete, we can fix for hearing.
my lord. Is it possible today, my lord?
Today it cannot be possible.
What about tomorrow, my lord?
Tomorrow we don't want to burden. Yes, what do you say?
My lord, as per our affidavit, my lord, our contention is we have already paid the, my lord, the compensation amount is, my
Now,
lord,
what about the Jirat part?
my lord.
Jirat also you have paid.
My lord, while making
Now
payment,
that 1,32,30,000 which you have claimed to have paid, what, does it include the Jirat compensation also?
my lord, that was the, my lord, the first, the
My lord.
entire compensation, my lord, assessed by the district administrations for making payment, my lord. Subsequently, my lord,
That was the entire amount. So the, who will make the assessment?
My lord,
Who will make the assessment? If you are saying that you have not been paid compensation for the Jirat,
assessment was done as per the minus of the meeting, my lord. If,
does it say anything about Jirat?
yes, my lord.
Where, page?
Kindly come to my lord, please. $53, my lord.
Of the restitution?
Type 1 is 53, my lord. My lord,
50?
Lordship body 53,
53.
my lord. Annexure 5, my lord.
Conclusion.
But come to the last portion, my lord. After the threadbare and prolonged discussion,
Okay. 53, yes,
53,
please.
last paragraph, my lord. After the threadbare and prolonged discussion and taking into consideration the above points, the members of the meeting arrive at the following 4 points decision. Number 1, the enhanced rate of land compensation should be paid to the landowner as per right to fair compensation and transparency in land acquisition, rehabilitation, resettlement act. The mark dumping ground should be acquired for project. The house damage of so and so forth shall be rehabilitated, compensated as per police report, and assessment of board compensation, standing crops and properties on ROW manner. And the OC on 116 RCC agreed to take up the matter to the higher authority.
After this meeting
My
of
lord.
29-3, what happened?
After this meeting, my lord, a board was constituted, my lord. Lordship kindly come to page 55.
5-5.
Annexure 6, my lord.
Yes.
Order dated 23rd May 2016. A board is hereby constituted for re-verification and assessment of agriculture / horticulture crop damage due to construction of
Yes, thereafter?
defense road. So and so,
Thereafter?
my lord. This survey shall be carried on so and so forth. This fresh survey is ordered in view of the complaints.
No, this is thereafter what happened?
Thereafter, my lord, please kindly come to page 56, the next page, my lord. A board is hereby constituted for re-verification and assessment of
No,
agriculture.
no, what happened? Did the board do anything?
My lord, thereafter, my lord, additional deputy commissioner, Anzaur district, my lord, prepared the property, my lord, assessment, my lord, for the property, Zarats. And the same is forwarded, my lord, at page 58, the assessment, my lord,
Okay.
up to 68, my lord. My lord, so far as the affidavit in opposition are concerned, my lord, so far the government of Arunachal Pradesh, the affidavit validates the abatements which the petitioners have taken, my lord. In this
Affidavit by?
Respondent, state government of Arunachal Pradesh.
Okay. They are supporting your stand.
Yes, my lord. And my lord, affidavit in opposition filed by the requiring body. The only ground for rejection of the prayer is it is at the belated stage, my lord. That is the ground, which in my
How
respectful
much is your claim now?
14 crores, my lord, 96 lakhs total. 96 lakhs, 14 crore, 96 lakhs, 90,400.
State government, what do you say, Mr. Ratan?
Our stand is that we have forwarded the estimate after the verification.
You had verified.
Yes, ma'am. We have forwarded it.
Now, what is your defense? Why don't you pay the amount?
My lord, our contention is, we have already paid the amount, my lord, by affidavit, my lord. My lord, just for a moment, my lord, may I take your lordships to the page number 5 of my affidavit, my lord. Affidavit filed by the, my lord, the commandant, my lord.
Respondent number?
Respondent number 1, 2, and 7, my lord. Sorry, my lord, filed by the Major P. Ankush.
Respondent number 1, 2, and 7.
My lord. Page number, my lord, 5, my lord.
Page?
Number 5 of my lord, reply.
Okay.
Married, man.
5 years.
Yes, man.
Paragraph?
My lord, just italic portion, my lord.
Yes.
No further claims will come up during the course of the constructions on account of any type of the compensations for the land properties from the any individual's land owners or the state government department, like Department of Agriculture, Horticulture, Department of Power, Department of PHE and Water Supply, and RWD, PWD, RWD Department, etc. In view of the above, there is no objections from this office for the undertaking the constructions of the above subject road to NHDL specifications with immediate effect. Hence, the submissions of the revised estimates after the 6 years was not accepted. What the department is contending is, one-time assessment was done, including the entire properties, and that has already been paid to the landowners and the public who entitled for the payment.
No, see, this initial assessment was sometime in the year 2015. Thereafter, phase 57, which has been highlighted by the petitioner, is of the year 2017, whereby bills have been forwarded to you by the duly constituted board. And if you see, if you see that the board also had your representative.
Yes, ma'am.
Then after after that, the latest communications, and after several communications was made between the department and the district administration, for a moment, may I take your lordship to the annexure, E, page number,
of your affidavit.
Page number, type of is page number 15,
15.
Yes, madam. Page number 50, madam, of my affidavit.
Yes.
This has been addressed to the additional deputy commissioner, the Anjo district highway and Arunachal Pradesh. Forwarding of the representations for payment of the land and the property compensations as per the RTFC LER, the Act 2013 for their 15 kilometers. But exactly the department is contending is at page number 16. You are requested to place the enclosed paragraphs of the damaged buildings with the bills, and the same is required for the ratings, the quantum of the damage by the competent financial authority.
Mr. Kato, what is in our mind is that they had made a claim for Jirat.
Correct.
That was reflected in the first minutes of meeting.
Yes.
Till that stage, let us assume that the claim was not genuine. To come to a finding of the genuinity, you had constituted a board.
Correct.
And the board was reconstituted. Both the boards had representatives, your representatives. You made a joint verification. Bills were submitted by the ADC. State government on affidavit says that the claim appears to be bona fide. Now, this exercise was done within a period of 2 years. Now, in the affidavit, if you come up with the stand that after 6 years we cannot reopen, that will not be justified.
It is absolutely, my lord, arbitrary.
Because it was already lying on your table.
Yes,
If you said that there was no movement, suddenly in 2022, a letter comes for payment. It was done immediately, and that too by a board having a representative of you.
Of all the stakeholders.
And the state has also, if the state has also raised some objections, matter would have been different.
Yes.
Now, this is not a case where you should deprive.
Absolutely. This is the only statement taken by the department saying that compensation is ascertained by the district administration and the past round we have already paid. And
Absolutely not cause and ground, my lord.
And by subsequent the assessment, they are refuting the
state government's affidavit.
By respondent 6, ADC and DC, 5 and 6.
Number
5 and 6, my lord. Respondent
and
number
6.
5 and 6.
Five.
5 and 6.
Separate affidavits.
Yes, madam. One is DC and the other one is ADC, Ireland. 6 is the appropriate authority who was dealing with the land acquisition.
Okay. 5, who's 5?
Deputy Commissioner.
No, 5 is the circle officer.
It is.
No, he is for the Deputy Commissioner.
Okay, 5 is the deputy commissioner.
Yes.
Is the additional.
Both stands are same. Madam.
Which page? Concerned page?
My lord, of respondent number 6.
6, yes.
Para 4 is there, my lord. Then para 6, my lord. Then para 9, my lord. Para 9 and para 10, my lord. Para 9, it says that the initial claim of 132 crores, 1 crore 32 lakh, that was for the value of land. And subsequently, the board was constituted for assessing the other properties.
Yes, Mr. Kamdug, anything?
I have no file affidavit brought in also to have not agree and going to the respondent I mean this
Okay.
They are not disputing that they have reassessed.
Okay.
And when the initial assessment, in fact, it's study proves and please you are not assessed. Absolutely. The reassessment was it's in the deputy commissioner with the authority to assess the limited reassessment commission and amount. And that the petitioners come to 14 crore
14.
access claims. It's state government has, in fact, they are not.
ADC.
Yes.
DC and ADC.
ADC and ADC with the authority.
Verifying authority.
Yes, verifying authority.
Okay.
It is still.
Okay.
The department.
Okay.
Dispute the state.
Right. Okay, heard Sri S.R. Rama, learned counsel for the petitioners. Also heard Sri M. Kato, the learned DSGI, comma, Sri N. Ratan, the learned AAG of the state, and Sri D. Kamduk, learned Standing Council Land Management Department. Full stop para. Considering the subject matter, comma, the pleadings exchanged, and as agreed to by the parties, comma, the instant writ petition is taken up for disposal at the admission stage. Full stop para. Please have your seat.
Sir.
The petitioners, who are 63 in numbers, have joined together with a claim for payment of the compensation in connection with a land acquisition proceeding initiated via a notification dated 13/11/2015 under Section 10 of the June Land Regulation Act, 1947 for construction of 0-15 kilometer within bracket from 143 km-158 km bracket close, comma, Hunli HUNLI dash Matangliang dash Hayuliang within bracket HMH bracket close Defense Road, full stop. It is the case of the petitioners that after the acquisition of the land, comma, while the compensation was assessed, comma, the compensation pertaining to the trees, comma, crops and ziraat was not assessed, full stop. It is submitted on behalf of the petitioner that while an amount of rupees 1 crore, 32 lakhs, 30,000, was paid to the petitioners with regard to the land which was acquired, the amount pertaining to the ziraat has not been paid, full stop. The said amount, the unpaid amount has been quantified as rupees 14,96, 98,469, full stop. Para. Sri Rabha, the Learned Council, has referred to a minutes of meeting dated 29/3, is it 29/3? 29/3/2026, which, comma, amongst others, was also attended by the representative of the 116, RCC, Hawaiian, HAYULING. Full stop. It is submitted that in the said meeting, the aspect of compensation for standing crops and properties on the ROW was also approved, full stop. By referring to the order dated 23/5/2016, Sri Rabha, the Learned Council, has submitted that a board was constituted for re-verification and assessment of agriculture, horticulture crops damaged due to the construction of the HMH Defense Road. And the said board, amongst others, also had the representative of OC, 116 RCC, within bracket GREF, full stop. Why another board?
On the date of survey was refixed. It's been initiated in continuation. It has been also mentioned, my lord, this has been initiated in continuation to this office order issued so and so forth, ma'am. The
It
earlier.
is also submitted that in continuation of the said order, comma, another order was issued on 19/1/2017 with regard to the survey which was required to be done for making the necessary re-verification and assessment. Full stop. Ultimately, comma, the assessment was done and a communication was issued by the additional deputy commissioner, comma, Anjao district, dated 13/10/2017 to the commanding officer, comma, 116 RCC within bracket GREF. Puts the by the said communication, comma, the bill for compensation arising out of damage to the compensation as assessed by the board was enclosed. Full stop. It may be mentioned that the requiring authority of the acquisition proceeding was the 116 RCC within bracket GREF. Full stop. Para. Instant writ petition has been filed. Full stop. Para. Sri Rabha, the learned counsel for the petitioners, has submitted that to verify the bona fide and authenticity of the claim, comma, a board was constituted which included the representative of the requiring authority, and the assessment was done by the said board, leading to the communication, leading to the issuance of the communication dated 13/10/2017. And therefore, there cannot be any reasons to hold back the said amount. Full stop. It is submitted that the petitioners have a legal right to receive the compensation which has been duly assessed. Full stop. It is also submitted that the verification exercise is not the subject matter of any challenge in any forum. And therefore, the findings of the board are required to be implemented. Full stop. Para. Sri Ratan, the learned AAG, has, by referring to the, has submitted that both the deputy commissioner and the additional deputy commissioner of the concerned district have filed separate affidavit in opposition. Full stop. by referring to the affidavit in opposition dated 10/7/2023, filed by the respondent number 6, the learned state council submits that the state is not raising any objection on the claim as the assessment was done by a duly constituted board consisting of representative of all the stakeholders, including the requiring authority. Full stop. Para Sri Kamduk, the learned standing council, land management, submits that he endorses the stand of the state government and no separate affidavit has been filed. Full stop. Para Sri M. Kato, the learned DHGI, however, submits that all the assessed amount was duly paid to the government for disbursal. Full stop. He, however, submits that with regard to the present amount in question, adequate explanation has been given in the affidavit in opposition filed by his clients. Full stop. Para, by referring to the affidavit in opposition filed by the respondent numbers 1, 2, and 7, dated 29/1/2024, the learned council for the central government has submitted that in paragraph 11 of the said affidavit, it has been categorically stated that vide an earlier communication dated 28/5/2015, it was communicated, it was informed that no further claim would be entertained. Full stop. It is also submitted that the revised estimate is not acceptable after 6 years. Full stop. Para, for ready reference, paragraph 11 of the said affidavit is extracted herein below. Green flag, huh? What's the last green flag? Page number 4 of that affidavit. Para 11, red mark, green flag. Para. The rival contentions made on behalf of the parties have been duly considered. Full stop. Para. The present claim of the petitioners relates to a compensation for compensation for for agriculture and horticulture crops and also ROW. Full stop. The minutes of meeting held on 29/3/2016 has clearly recommended payment of such compensation for standing crops and properties on ROW, and the said meeting, amongst others, was attended by the OC, 116 RCC, as noted above. Full stop. The board constituted for re-verification and assessment in the said aspect also included members of the requiring authority, namely the OC, 116 RCC within bracket GREF. And the said board was constituted in May 2016 itself, and via a subsequent notification dated 19 January 2017, the survey was also notified. Full stop. The recommendation of the committee after assessment was duly communicated on 13/10/2017 itself by the ADC to the OC, 116 RCC within bracket GRF, along with the enclosures containing all the details. Full stop. A perusal of the enclosure would show that the following details were given. Full stop. Number 1, name of the victim. Number 2, village. Number 3, distance. Number 4, location from the road / alignment. Number 5, name of the crops. Number 6, number 6 is name of the number 5, name of the crops. Number 7, number 5, name of the crops. No? Number 6, numbers / numbers. Number 7, age of the plants. Number 8, rate. Number 9, value. Full stop. All the assessment sheets were duly signed by the concerned officials. Full stop. Para, this court has also noticed that in both the affidavits filed by the Deputy Commissioner and Additional Deputy Commissioner, the claim of the petitioners instead of has not been refuted, and rather recommendation has been made for such release. Full stop. Para. The only objection which is seen from the affidavit of the requiring authority is that there was a communication dated 28/5/2015 regarding final compensation, and no further claim was to be entertained. Full stop. This court has, however, noticed that admittedly the amount of rupees 132.30 lakhs was the final compensation for the land and was not pertaining to the Jirat. crops and ROW. Full stop. Therefore, comma, the present claim is not in connection with the land in question, but for the GRAP which has been specified. Full stop. This court is also unable to accept the submission made in the said paragraph that the revised estimate, that after 6 years, the revised estimate cannot be accepted, full stop. The acceptance of the same cannot be construed from the date of filing of the writ petition or the affidavit, but from the date on which the assessment was notified and communicated to the requiring authority, which was done on 13/10/2017 itself. Full stop. Therefore, comma, the delay, comma, if any, is on the part of the requiring authority, for which the petitioners cannot be found fault with. Full stop. Para. In view of the further discussion and there being materials to show that the assessment was arrived at by following a due process of law and in a transparent manner, comma, this court is of the view that the petitioners have been able to make out a case for interference, full stop. Well, in view of the above, comma, it is directed that the assessed amount for the three words, no? For the assessed amount for the standing crops and properties on ROW as communicated by letter dated 13/10/2017 amounting to rupees so and so, 114, be released to the petitioners expeditiously, and in any case within a period of 2 months from the date of receipt of certified copy of this order. Full stop. It is since the amount was entitled to by the petitioners, comma, the amount would also carry interest from the date of issuance of the said notice at the rate of 6% per annum. Said petition accordingly can dispose of.
Deeply obliged, madam.
Deeply obliged, ma'am.
Item 10, contempt. Who's appearing? 15 matter
My lord,
yet to be complied with.
my lord, they filed an affidavit which found to be contradictory, my lord. As per direction, my lord, judgment, my lord, we are supposed to publish the result, my lord. Now they have stated that the petitioner is not eligible and has not been recommended. Now, and the post that the mean for PWD, my lord, OBC category that has been re-advertised. Now, in the subsequent re-advertised, they say that in corrigendum, by way of corrigendum, say that since OBC Hindi that has already been filled up, therefore, even in fresh advertisement, the candidate who's interested, they need not to fill up in that post, madam. That has been, that's contradictory is there, madam. So strictly, my lord, since it is a contempt, my lord, so they found to be playing with the judgment of the court, my lord.
My lord, as per the direction of this honorable court, we have communicated the result to the petitioner by through register post. And
Where is the direction? Let us see.
My lord, direction it at page 78 onward, and 88 is operating, my lord.
88.
Yes, it start from 78, and 88 is of 89 onward, my lord. Para 19, my lord.
Yes, please read.
In view of the circumstances, my
Declare
lord.
the results.
Yes, my lord.
And if the petitioner is found to be successful in his case may be considering 3% so and so. You have declared the results.
yes, my lord.
Where? Page. You have filed affidavit.
Yes, my lord.
My lord, in their affidavit,
That is in my affidavit, my lord. That is at NHR 2 series, page 22.
Two series. Affidavit by 1 and 2.
Yes,
Page
page 22, my lord.
22.
22 and 23.
my lord.
22. Yes. Yes, please. My notes of the committee considered 10 no one suitable. Okay. Yes, what is your contention?
My lord, my contention. My lord, let's see their affidavit. It's under page para 6, my lord. Page 6. Now,
Actually, we find that the direction of this court has been complied with.
My lord, yes,
Declare
my
the results.
my lord,
If
only,
you want us to go deep, then you have to file a writ petition.
my lord.
Contempt is only to see whether there is compliance of the order.
My lord.
The compliance may not be correct. It may be wrong. It can be subject to further scrutiny by the court. But as a court examining a contempt matter,
My
we
lord.
need to see. We
Only-
can give you liberty.
My lord, that one. Only my lord, only my concern, my lord, they have not projected in a bona fide manner. That's
Okay,
only, my
well,
lord. That-
Third Treaty Tagum, learned counsel for the petitioner who has filed this contempt petition alleging non-compliance of an order dated, of a judgment and order dated 28/4/2015 passed by this court in WPC 187 AP of 2012. Full stop. Para. The operative portion of the aforesaid judgment is extracted herein below. Page 87, paragraph 19, quote. Para. It is submitted that in spite of the clear direction, comma, the same was not complied with, full stop, para. On the other hand, your name, learned counsel for the respondent number 1 and 2
Yes,
has submitted that the order has been complied with, and in this regard, comma, he has referred to the affidavit in opposition filed on 31/5/2016 by the said respond numbers 1 and 2. Full stop. Para. By drawing the attention of this court to annexure 2 series of the said affidavit in opposition, comma. The learned counsel for the respondents has submitted that the selection committee, after due deliberation, has found that under you are the OBC category.
My lord, no, OBC, my lord.
Under the
OBC
OBC
PW.
category, comma, no one was found suitable. Full stop. Para. Sri Tagum, the learned counsel for the petitioner, however, submits that the aforesaid communication lacks bona fide,
My lord.
and the same has been done only to deprive the petitioner. Full stop. Para. The concern of this court in examining a matter alleging contempt is to see as to whether the order passed by this court appears to have been complied with. Full stop. The correctness of such compliance may not be a part of such adjudication process, which, however, can be raised in an appropriate petition. Full stop. Para. In view of the above, comma, the instant contempt petition is closed, comma, however, with a liberty to the petitioner to challenge the correctness of the order passed by the authorities.
Deeply obliged.
Made on behalf of the petitioner. List after 2 weeks. 13 and 14.
13 and 14.
Yes.
Your Lordship.
Contempt matter.
Yes,
What is this?
for compassionate appointment, we have received affidavit from respondent number 3 this morning. So now respondent number 1 and 2 have to file.
And regards 3, will you be filing your rejoinder or take instructions?
We will take instructions.
You for?
Respondent number 3.
You have filed the affidavit?
Yes.
1 and 2 have been served otherwise?
Yes, we have served.
Who is appearing for 1 and 2?
I don't know the councils.
They have not been served, madam. 1 and 2 are yet to be served. When did you take steps?
Yes, Lord.
Who are 1 and 2?
It's Secretary Land. 1 is Secretary Land, 2 is Director of Land Management.
Mr. Kamduk, is he there? Kamduk.
No,
I have
Lord, he is
requested
left.
him to inform. Contempt matter, it's up to the parties to engage new their own counsel, but at least he could have informed. The respondent number 3 has entered appearance and has also filed affidavit in opposition and is represented by your name.
Jikato.
G.
Kato.
Kato, G. Kato, the learned counsel, full stop. Para. Madam, you are, Somo, S. Somo.
Yes, Your Lordship.
Ms. S. Somo, learned counsel submits that some time may be granted to enable her to obtain instructions on the said affidavit, full stop, para. Office note dated 16/11/2023 reflects that service report in respect of respondent numbers 1 and 2 are still awaited, full stop. The notices were dispatched on 11/7/2023, full stop, para. Let fresh steps be taken upon the respondent numbers 1 and 2 by registered post with AD. Steps within 2 days. List after 4 weeks along with service report on the respondent numbers 1 and 2.
Major.
My lord, item number 17 is an IA filed by the Deputy Commissioner
Okay.
against.
You're fine. Who's for the deputy commissioner? You are for the
In these cases, the deputy commissioner has appointed their own counsel.
private counsel.
Your Lordship, I'm for the respondent number 4.
Okay.
In view of that, and the last order,
IA for?
IA for recalling of the, vacating the interim order.
Your Lordship, my learned senior counsel is unable to appear before this honorable. T. Sunil. T. Sunil. Yes, his health is not well, so he is unable to appear.
We'll have
today.
some other date then.
Yes, it may be fixed on, Your Lordship, this 15th of
Next
February.
Monday?
15th February, fixed date.
15th February. Madam, is it okay for you?
Yes, Lordship. In that case, interim order may be extended.
We'll extend the interim order. What is your name, madam?
M. Yaram.
Ms. M. Yaram, learned counsel, appearing on instruction of our senior Sri
T. Sunil.
T. Sunil, learned counsel submits that the IA has been filed by the deputy commissioner, by them on behalf of the deputy commissioner.
Sorry for interruption, Lordship. In view of the last order, this honorable court was pleased to direct that instead of hearing the IA, the matter itself will be heard. The writ petition itself. Yes.
Who has filed the IA for? Okay, what was the line? Deputy Commissioner for modification of the interim order. First of however, comma, her senior could not be present today due to health reasons, full stop, para. As requested, list on 15th of February. Now 15th is a holiday, it seems.
15.
Are we done 16th of February?
Yes,
Madam?
Your Lordship. Yes, Your
16th,
Lordship.
1/6, Friday.
Yes, Lordship.
16th February, para, interim order passed earlier, stands extended till the next date of listing.
In all the cases, Lordship.
We are passing in IA. This will be a common order in all the. Yes.
Your Lordship, affidavit has already been filed by the respondent number 3 and 4.
Yes, ma'am. When was it filed today?
No, my lord.
Earlier,
my lord, but
You have filed rejoinder.
no, but their department
Lordship, I'm
Affidavit
appealing
is
to
required.
respondent number 1 and 2, Your Lordship. I need some more time, Your Lordship. I've received the instructions.
3-4.
3 and 4.
3 and 4.
3 and 4. Private respondent.
Private
Private
respondent.
respondent, Your Honor.
How much time, madam?
2 weeks, Your Lordship. I've received the instructions.
Okay. Though the respondent numbers 3 and 4,
May I, my lord? Well, interim order is there, my lord.
though the respondent was 3 and 4, represented by
Private, B. Mema.
Ms. So-and-so, has filed affidavit in opposition, comma, the state respondents represented by Ms. R. Basar, the Learned State Council. Do so it says file affidavit, comma. Ms. R. Basar, the Learned State Council submits that affidavit is yet to be filed by the state respondents, full stop para. She accordingly prays for and is granted
2 weeks.
3 weeks time to file the affidavit, full stop para. Interim order passed earlier stands extended till the next date of listing.
Much obliged. Here also, my lord, affidavit is required, my lord, yet to file.
You have to file.
No, my lord, I'm for the petitioner, my lord.
They have not filed affidavit.
Yes, my lord.
I'm appearing on behalf of Standing Council, Peter for UD and also.
UD, you have filed affidavit?
No, Your Lordship.
And madam?
No, Your Lordship, I need time. Your Lordship.
You'll
I'm
seek
appearing
time.
for 1 and 2.
Both Ms. R. Basar, Learned State Council, as well as three.
Respondent number 3.
Your name?
E. Major.
E. Major, Learned Council appearing on instruction of repeat of Standing Council, UD and Housing. Pray for and are granted 3 weeks time to file affidavit in opposition. Yes.
Much obliged.
Item number 26, on last occasion also, I especially asked for this early hearing, lordship, because this is 2020 letter and this is regarding ALG, lordship. The petition.
Regarding?
Advanced landing ground near the
Advance?
landing ground. They have constructed a building, lordship, the petitioners.
Okay. You can hear this, what is for hearing today?
Yes.
Your Lordship, we have not filed our reply to their affidavit. Your Lordship.
We have counter affidavit, we have filed way back in 2022, lordship.
Oh.
This is just a lordship excuse because
2
they
years
have the interim, lordship.
2 years, we cannot grant you to file an rejoinder.
Yes, lordship.
And
And
there is an interim order.
many a times they were absent also.
In
So
that case, we'll vacate the interim order.
yes, this was DFD also, lordship, one occasion, lordship. And then again, they have filed a IA. It was reinstituted in 16/6/22 on.
But the interim order is not extended, it's only restored.
But then lordship, it is in their understanding that interim
No,
is
you
there
instruct,
already.
you advise your clients. Writ petition was dismissed for default, it was restored. Interim order has not been extended. We'll clarify that. We'll grant time, we'll say that there is no interim order operating.
Under the garb of interim, they have already constructed, lordship.
No, we'll say that there is no interim order. You.
Lordship.
Your Lordship, actually, we had sought some information and data from our clients.
No
and
information.
they had,
No, there is no interim. If you're seeking time, we'll grant you time, but we'll clarify that there
Lordship
is no
can come
interim
to
order.
my affidavit also, lordship. The airport authorities, they are giving us letters to the.
You have not filed rejoinder for 2 years, why?
Lordship.
My lord, we sought some information which we are not getting, my lord.
No, then can we wait for
That- that
indefinite
would be
time? We cannot.
Short period, my lord, at least 2 weeks.
No,
No,
see, it's a
lordship.
matter of 2020.
I understand, my.
And they are urging that in matters of grave importance, urgency is there, interim order is there.
Lordship can come to my affidavit also,
As a
lordship.
last
Notification is already
2
there, 100 meter to 900 meter. They are not allowed to construct,
Okay, we'll
lordship.
fix a date, will
And-
not cause prejudice to either you, but we'll say something regarding the interim order.
As per verification, within
prayer
50
for
to
adjournment
20
has been
meters.
A prayer for adjournment has been made on behalf of the petitioner. Full stop para. Ms. G. Ate, the learned additional senior advocate, however, submits that the matter is of the year 2020 and on many occasions, the adjournment has been sought for.
Lordship.
And there is and there was an interim order which was passed.
Yes, lordship.
Full stop. She therefore objects to the prayer for adjournment. Full stop para. This court has noticed that this writ petition was dismissed due to non-prosecution on 11/5/2022. Full stop. However, vide a subsequent order dated 16/6/2022 comma, the writ petition was restored to file, full stop. It is also noted that that the interim order, however, was not extended, full stop. In the said order, comma, the matter was to be listed for final hearing after the summer vacation, which was of the year 2022, full stop. Para. The adjournment sought for does not appear to be justified at all, full stop. Para. Be that as it may, comma, and in the interest of justice, comma, our last opportunity is granted fixing the matter for hearing on 8th of February 2024. Para. It is, however, made clear that there is no interim order operating in this writ petition.
Highly
Much obliged.